Good morning, everybody, and happy Thursday, July 21st, 2022, here in Hangouts and Headlines. Sorry, I was a few minutes late there trying to hit those times. As you know, from Tuesday's stream of Hangouts and Headlines, we've gotten an upgrade to our internet at Hoeg House, and like all upgrades to information technology, it's not working perfectly right off the bat. So we have to make a few more tweaks, and I'll be handling that for the rest of the day, probably. We'll see. Hopefully it doesn't take quite that long. But for right now on this stream, my sincere hope is we got the download and upload speed sufficient to have this conversation with you and to get rid of some of those fogginess, out of focus, out of time speech patterns that you saw from some of the episodes last week. So let me know if you do see any issues here, because I'm always interested in trying to address those kinds of things. But ideally, we should be all set up now with, well, what amounts to a YouTuber's internet connection at this point. Never thought I would say that about myself, but we have to be honest now at this point. I'm doing this a lot more than I had ever anticipated when we started it up. And that's because, well, quite frankly, it's because of people like you that come and join me at 7:30 in the morning of the East Coast of the United States. And I am so happy for it. I'm so happy we get to have these conversations. On the thumbnail, you saw that I covered a specific headline about a Uber. Yeah, good start to the Thursday morning already. An Uber settlement that was entered into between the company and the federal government very recently about wait times that I like. I think it's interesting. I think it's an interesting story. It's interesting to think about Uber and Lyft and what they actually are. Are they actually public transportation companies? Are they, as they claim, connectivity companies, essentially putting people together that are otherwise providing those services independently? Certainly, we've seen things like the state of California having to deal with that question, figuring out whether people that drive for an Uber or a Lyft or a DoorDash are actually employees, whether or not they should have the same protections as other employees situated in those states. And it's very interesting to think about, because one of the things that comes up in virtual legality a lot, right, is this notion that the law moves slowly. And it really does. It moves very slowly, not just because legislatures tend to get caught up in their own business and not be able to figure out what they're doing at any given moment in time. We know that to be true. That's not unique to the United States, I don't think. But also because even when the legislature moves on these topics, well, that's just words on a page, right? They will have set forth certain things. And if they did their job remotely rightly, it will be clear what the law does. But very often, well, quite frankly, it isn't so clear. And so when we talk about these things, we're actually talking about a law that gets debated and negotiated and passed at some point in time. And then, and only then, does that get kind of filtered out to the people. And then the people have to deal with it, try to figure out exactly what they're looking at with respect to the law. And the court system ultimately has to come into play. So if you just imagine how long we've been looking at trials or court actions, not, of course, if you're Twitter and Elon, who are having a trial in about 3 months, which we will, of course, cover here, especially if they let us see it publicly. But we'll continue to cover that story as it goes. I still say settlement on that. But I digress. That process takes a long time, right? If we were talking about Johnny Depp and Amber Heard in this particular episode, we'd say, wow, that was years and years later, even from when the initial complaint was filed for defamation by the Johnny Depp side of the equation. It just takes a long time to get things done in the law. And so when you talk about things like ride sharing services, or God forbid, something else with a number of random letters that's now an app on your phone that does something that we can't even imagine by the time this episode is done, the law is generally ill-equipped to handle whatever it might be, right? And so that's part of the interesting bit of practicing law, right? Is that the human condition, society, legislatures, contracts, everything else never stops changing, never stops being described differently. If you like that kind of problem solving, then you're in luck. You should consider being a lawyer, a transactional lawyer, or maybe a politician or a legislator. God knows we need some that can write laws more clearly. But if that makes you crazy, if you look at that and say, well, Rick, that's not an answer. That's not a bright line. That's not anything that we can build our lives around. I have to say that, yes, understanding how these systems work, understanding how the law works, how these things get interpreted, how long it takes for them to be interpreted is kind of unmooring, right? There aren't these rules. You don't just color between the lines. Everything is constantly changing. And then if you're cynical, if you're nihilistic, if you're just on the internet or on Twitter on a regular basis, then one of the things you argue is that all of this is just, Nietzschean power exertion, and there aren't actual practical rules of law and things like that. No, I don't believe that here in Virtual Legality. I advocate for process and law all the time. But there are instances where certainly things look a little bit askew, and people take those and talk to me about them and leave me comments about them, and I don't blame them. So, yeah, quite the intro for today's episode. A little philosophy at the start here. We also got a super chat from Britt, who's constantly super chatting here. Britt, thank you so much for the support of the channel. Britt Cormier, law moves slowly because we have to wait for the courts to tell us what the law really means. How many laws have had strange effects in our lives due to unintended meanings? Yeah. Well, not only that, right? Because the court is supposed to be able to interpret these things and explain what they mean. And then that sets precedent for the next time that they would interpret these things. Then that might go up the ladder, and that'll set precedent for the courts below them, all the way up to the Supreme Court, possibly. But then, even then, right, we talk about Supreme Court precedent all the time in this space where reasonable minds can differ about the philosophy of reading something, right? Should you read it by trying to figure out what the legislature meant when they put together these words? Essentially, giving you the option of ignoring what the words actually say to try to read the minds of the legislature. I've talked about that with respect to Bruin and Dobbs and the issues that I have with that kind of process. You can also do a more Gorsuch-like approach. You can be a kind of programmatic textualist that says, I don't really care about reading your mind, legislature. And this can happen at the Supreme Court. I'm talking about Gorsuch here, but it can happen at the state courts at any level. And you say, okay, you intended it to say this, but these aren't the words you wrote. And we can only go on the words that were written and that you voted on and that you passed. Because when I say you intended this, I'm meaning one or maybe a group of people. I can't attribute that to the whole legislature. And maybe half the legislature said, oh, you wrote that wrong. We're going to drive our truck through that ambiguity. And that's why they passed it in the first place. So a textualist comes in and says, nope, I'm going to read it. I'm going to say exactly what I think it says in English. I'm going to solve ambiguities using the various doctrines that court systems have in common law in United States history, and I'm going to apply that to this particular circumstance. But yeah, that'll get you a different answer than an originalist answer. And then on like the complete other side of the coin, you have kind of the living document, living statute, intentionality, even more than originalism. What was the spirit of this law? This law should be changing to reflect something that has changed in modern life. That goes down to the Constitution, that comes up to the statutes. All of those philosophies will get you different answers. And I think when we talk about those things here, sometimes people get unmoored, right? I don't blame them. You look at it and say, well, Rick, I've been told that there's this system and it works in this capacity and it does these things. And in fact, you've told me that, Rick. You've told me, we should be in favor of a rule by law and not by men, all those kinds of old-timey philosophical ideals, because I believe in them. I believe in avoiding like that authoritarianism, that totalitarianism that you might like in one instance, but you'll hate in the next, and having that kind of mercurial control over people's lives. But in terms of judicial philosophy, all of those are legitimate to some extent. Everybody's going to have one that they favor more than the other in all likelihood. But it does mean that it is very much in flux, the legal process. And this is all without even getting into Uber, right? The reason I brought this up to start was that Uber doesn't match up with what these laws were written about, right? We're going to be talking about laws written primarily in the 1960s. And they had no concept of ride-sharing apps. They had no concept of apps. They had no concept of cell phones. I mean, we can take this down and down and down and down and down. And ideally, in a fully functional system, thank you, Britt, for the super chat, you would say, well, the legislature would look at the changes in modern life and they would either amend or revise the existing laws or pass a new one to reflect whatever changes the current body politic thinks is important to be regulated or otherwise. And that would be the way these things would work perfectly. Instead, what tends to happen is that you've got a law in the books that maybe was fought over tooth and nail, say 60 years ago, and nobody really wants to tweak it. Nobody really wants to upturn the apple cart there. And so they leave it to the executive branch. Here we'll be talking about the Department of Justice, or the judicial branch, the courts, to go and interpret things the way they want them interpreted. And people will come into my comments. People will otherwise talk to me and say, well, Rick, doesn't that mean that the legislature of the United States is fundamentally broken? And I would say maybe. I know, lawyers, right? What can you do with us? I would say maybe, because inaction is actually a kind of choice by the legislative branch, right? When the legislature decides not to do something, and we say decides kind of loosely here because it's 535 people, is when they decide not to do something, that is, in effect, the federal government, or at least the legislative branch, deciding not to act for whatever reason. Sometimes we can't deign to guess. Sometimes it's 40 reasons. And we could argue that that is something that is in and of itself representing the will of the people. People don't like that answer, right? Because the tendency is on one side or the other of the political spectrum to say, well, if something isn't happening to solve problem X, or doing something that this particular side or the other believes is something that is a good, then the process is broken. Congress is broken. And I think there's an argument to be had that no, that's not the case in a divided country. And we're pretty divided. Let's be honest with each other. In a divided country, you would expect a certain amount of inertia if you can't get those kinds of agreements together. And maybe that's something that needs to be looked at from a kind of real politics standpoint. But in terms of the way our processes should work, you would expect standstills. You would expect roadblocks. And that is to some extent what we're seeing right now. And people have issue with that, right? Well, we should, I say, hey, we've got a process to amend the Constitution. We could go through with that. I said, well, that's too hard. It's kind of a feature, not a bug, is that you don't want to impose on people that don't want to go in that direction. So you make sure that a huge percentage of either the state governments or the people approve things like a constitutional change. Same could be said about statutes and representatives. And so when we look at these kinds of questions, that is fundamentally part of the discussion. Is inaction acceptable? And what you'll see in the news is it's not, right? If you look at the media, it's always and everywhere the case that inaction is brokenness. We must do something. Whether or not that's a good something or not, your mileage may vary. Reasonable minds can differ. But there's a constant push to doing things to answer problems and to answer questions. And I think that's an interesting part of watching how laws get made and how things move around within the political system, which is just an enormous, 15-minute digression. But, these are the thoughts that a lawyer has, or at least I have, with respect to watching all these things happen. Right? We've been doing headlines now for a little more than 2 months, I think. We're coming up on 3 months, I believe. And I've had a fantastic time. We've obviously covered a lot about a very specific trial. But one of the things you'll see in this space, I think, more often is me just pulling up headlines I think are interesting, right? Stories that I think I can add to, stories that I think are worth reading with you all. And hopefully you like that process as much as you like us just kind of commenting on editorials that castigate all of us and throw us down into a pit of Pirates of the Caribbean fans or what have you in any given day. Undoubtedly, those will continue to come up. Right now, I have a loose, casual rule of no more than one Depp v. Heard article per week. I have to believe that the media is going to stop these articles relatively soon. He says naively, if they get clicks, if they get views, I suspect we'll see a lot more of them. But I'm trying to not make this the Johnny Depp versus Amber Heard morning show. So we're going to try to go further than that with some of these things. And one of those is interesting things about technology. That's obviously what we love here, virtual legality, video games, software, technology, and more. I think I say a bunch at the end of those episodes. And legal impacts of trying to deal with technology and those kinds of things. But with that said, let's look at a few comments. I think I already went 20 minutes past, where we get where y'all are tuning in from. But I really appreciate each and every one of you, all the folks that do this on a regular basis in the morning. Especially we've got 300 people here. Uber not necessarily driving the clicks and views that maybe a Depp v. Heard headline would. And I appreciate every single one of you. I'm enjoying this. I think we're only going to grow and have more fun in Hangouts and Headlines as we start to broaden out and talk about new things. So definitely tell your friends, subscribe, do all that fun stuff on YouTube. But I really just wanted to say hi to everybody. Tracy Fagan, good morning, everyone. Good morning, Tracy. Pew, pew. By the way, hello. Hello to you, pew, pew. We've got some conversations going on here in the chat about various, I guess they're political philosophies. I don't know. This this is kind of a legal concept to me. I care more about that than things like elections and polls. So I think of it as slightly differently, but you're not wrong, chat, that they do have kind of a political bent. Let's see here. Britt is talking about, I hate supporting YouTube sometimes. I still know most of my money is going where I want it instead of where someone thinks it should go. So yeah, it's going here. YouTube takes 30%, but I get that. They're talking about politics. They're talking about philosophy. If you like that kind of stuff, get in our chat, which I'm already communicating to the chat, so that doesn't help so much. But let's see here. Secret McSquirrel says, I'm just here for the hangouts. Heart emoji, smiley face. Like I said, I've said it before in prior episodes. Different people think different thoughts about the hangouts and the headlines portion. Yes, co-counsel. So when she talks that long and it's just silence on the stream, I apologize. Maybe I should get her like a microphone and like a button she can call into, like a radio show. Just have the producer come in and make no mistake. In a very real way, co-counsel is a producer here because I can't live or speak without my tea. Delicious. And I can't really do anything that we're doing behind the scenes that you can't quite see yet, but you will very shortly without co-counsel. So I will say this, right? Deputy Heard, you say sweet summer child to me, put some thoughts into my head about the world and how these things can go down. Didn't love that, but all of this has brought me closer together with a number of my colleagues on YouTube. A lot of this has brought me closer together with my wife. And I am so thrilled that here in like the 4th year of the channel and Virtual Legality, she's taken on this role that she, I think, really loves and is absolutely important, critical, really, to getting this done and having these conversations with you all. And I love it. Who could have thought me picking up a microphone in November of 2018 would result in, my wife and I having a new kind of avenue to discuss in terms of a YouTube channel. It's crazy. So I love you, honey. Thank you for that. And the question that she asked me to reflect on from earlier in the chat stream was this notion of, does that political philosophy of how rules are interpreted, how we should look at these things, apply to sports and board games? And I would say that in general, no, not quite. Because when I watch a sporting event, especially if I'm invested in it, and you really shouldn't be judging things you're invested in, I will 100% talk about the rules, and not only the rules as applied, right? What the rules are and how they impact this specific situation that I'm watching in a sporting event. I will also advocate for rules changes, right? And generally, if you know me, or if you've been following me for a while, you know that if you follow my Twitter at Hoeg Law during Michigan football season, you will see me very animated on my Twitter. It's probably the most animated that I ever get because I am a diehard fan of the Michigan Wolverine football team. They don't always give me a lot to cheer for. Last year was the exception. That's why I have Big Ten champion shirts and Big Ten champion hats. And maybe I'll wear some more of those on these streams, maybe on Casual Fridays. Maybe I'll do things outside the Hoeg Law hat system on Casual Fridays. But no, I will advocate for rules changes. Rules changes, I think, are good, but it's not really that kind of passive, here's how things happen, let's keep everybody to their lanes. It's much more animated about that. And when we play board games, I think some people would call me a rules lawyer, where I'm constantly interpreting exactly what the sentences in the rule book says to specific situations. And my brother, who happens to be a game designer, I mean, whatever, I don't know if that gives you more street cred on these questions than mine, goes forward and will argue with me and sometimes yield, and sometimes enjoys that process and sometimes doesn't. So, hey, Tom, I hope you enjoy that process more often than you don't. And we'll get you on a 2 Hoegs Are Better Than One episode before too long. Hold tight. We'll see. We'll see if we can make that happen. So no, I view sports and games as something a little bit different than like my career and working within the systems that I have. I see a lot of other people saying hi to everybody. Working with co-counsel, says some people. Don't worry about some other things. And yeah, fantastic. Let's see. What else we got here? Go Blue from Pew Pew. Like I said, diehard Michigan Wolverine fan. Those of you that are Buckeyes fans or Spartan fans, I appreciate you, maybe even doubly so, because you have it within yourself to still watch and hang out and have fun with a Michigan Wolverine, and an unabashed one. So reasonable minds can differ. They just can't differ during like 3-hour blocks on random days in October and November, right? We'll be enemies, mortal enemies for those periods of time. Then we'll come back together afterwards. I'm sure I'll hear from you all during those game weeks. Since we were never running live streams during college football season, I look forward to the gentle ribbing that I am sure I will get for when my Michigan Wolverines undoubtedly trip over their own shoelaces, which, has happened before. All right. Well, let's stop Hangouts for a little bit. Let's go and talk about Uber. So in November of 2021, Uber is sued by the Department of Justice. And for the most part, I'm using Verge articles here. This is where I found them. I like to use the articles, if assuming they don't have separate primary source material, where I will always link to before, where I find them. I like to give credit to these places. Verge does a lot of good work. Keep your eyes on this space, since I gave an interview to the Verge for like an hour or more on a completely different topic. So there might be a pretty big blowout piece at some point. But the Verge does some good work, and they identified this federal lawsuit in November of last year that was about wait times, right? And I don't use Uber, so let's give the tilts, the biases, the understandings out there ahead of time, or more specifically, when I do use Uber or Lyft, it is on an occasional basis. It is, whatever makes the most sense at the time, airports and whatnot, and I don't use it very often. The Verge reports Uber discriminates against people with disabilities by charging them a wait time fee while entering the vehicle, according to a new lawsuit filed by the U.S. Justice Department against the ride-hailing company. So Uber has a wait time fee. The implication here in the first sentence, and honestly also by the federal government, is that is specially aimed at folks with disabilities. Turns out that's not the case. It just affects people with disabilities more than people that wouldn't have those things, as you might expect, since it takes them a little bit longer to get into a car. And that becomes a legal kind of question, right? If you apply a facially neutral policy to a situation that has what we would call in legal terms a disparate impact on a protected class of people, what should the law do about that? Right. And I'm not going to sit here in Hangouts and Headlines on a YouTube stream and tell you how you should feel about the application of things like the Americans with Disabilities Act. But it is worth going through the process, as we did if we're lawyers in law school, and not just kind of knee-jerk saying, yeah, of course, people with a wheelchair, people with disabilities should get special accommodations, or companies shouldn't be doing this kind of thing against them. That is understandable and honestly warranted in a lot of respects. The question is it discriminatory? Like, at a fundamental level, to say, if you make the car wait for more than, I think it's 2 minutes, we'll look at this, then we're going to charge a sitting fee. We're going to start running the clock at the 2-minute mark. Is that something that is discriminatory? Now, actually, the law is going to cover this question pretty directly. So we'll see that Uber, as long as you think of them as a public transportation company, which is the big fight that Uber always has, and we'll talk about that as well. As long as you consider them a public transportation company, generally speaking, has to allow for time for these people to get into the car. So that's going to answer this question pretty fundamentally, although Uber disagrees. It is still worth thinking about that. Okay, if we have that kind of neutral application, but it happens to affect people more, is that something that's a problem, especially if it can be justified, right? Uber can go back and say, well, if a car is sitting, our system isn't functioning as well as it should be. And so for whatever reason, we don't care. We're neutral on the reason. Your movie ran long, and so the car was sitting for 15 minutes. You get there and you have to pack a wheelchair. We don't care why. We just care that it happened. Now, the alternative argument there is if the car shows up and you're right there ready to go, and it takes you that extra time to pack a wheelchair or something along those lines, what did you do that was a problem? And I think you've got a better justification there. So one of the things we'll be looking at is their procedure, because I think a better answer, and maybe this was a technological impossibility, is to say, if you are at the car, then you're good, rather than when the car leaves. It's everything within your power. I'm at the car. If I'm in a wheelchair, then it takes what it takes. But if I'm at the car, we don't have a wait time kind of concept. And that didn't happen. These extra fees have harmed many passengers and potential passengers with disabilities throughout the country, some of whom may be entitled to monetary damages, the department said. The lawsuit, which was filed in the U.S. District Court for Northern California, alleges that Uber is in violation of Title III of the Americans with Disabilities Act, which prohibits discrimination by private transportation companies. We've got a couple of sections here to pull up. So here we have 42 U.S.C. section 12184, prohibition of discrimination in specified public transportation services provided by private entities. And it says, no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of specified public transportation services provided by a private entity that is primarily engaged in the business of transporting people and whose operations affect commerce. This is what we call the commerce hook or commerce tag. This is what allows the federal government to pass laws of this nature. They are only, ostensibly, by the Constitution, allowed to regulate things that affect interstate commerce. And so they have to say that effectively in every statute that is passed on basically every topic in the United States. Now, this pretty much does what it says on the tin, right? If you can't discriminate, what do we mean by that? Well, for purposes of that subsection, discrimination includes the imposition or application of eligibility criteria that screen out or tend to screen out an individual with a disability. That's not really happening here. The failure of such entity to make reasonable modifications to their service, to provide auxiliary aids and services consistent with the notions put forth here, and to remove barriers consistent with all these requirements. That you, in order to avoid discrimination, have to help a little bit under the ADA. You say, okay, well, that sounds like it might apply here. Uber charges for a wait time after 2 minutes, and they could say, hey, if you have a disability, you get 5 minutes, or whatever. You could do things to accommodate folks with a disability. And one of the questions is that Uber started to do that just before this lawsuit was filed, and we'll see exactly why that's funny when we get to what the settlement entails. But the real question that Uber always raises is this one. What is a specified public transportation service? And again, we can go to the next statute. This is what lawyers do, right? I have fun with it. I like doing this kind of thing. If you don't like bouncing between statutes and trying to put together what the rules of the game are in any given instance, maybe you don't like it as much. But that's a defined term. We're going to look at it here. The term specified public transportation means transportation by bus, no, rail, no, or any other conveyance other than aircraft. Well, yes, we are. We are another conveyance than by aircraft that provides the general public with general or special service on a regular and continuing basis. And the reason Uber brings this up all the time is because they would argue, well, we're a bulletin board, right? We are a payment facilitator. We run credit card payments and we get money to various parts. But ultimately what we do is we provide, an application that links people together. Now, to some extent that works. To some extent, that's not a great fit for what this definition says. They aren't providing transportation. Uber isn't, right? Uber's providing you an app. The driver's providing the transportation. Uber's making sure that the driver gets paid. And they use that in a number of jurisdictions to kind of get around certain regulations that affect things like this. So it's a bad fit, or at least it's an unclear fit. It's a round peg in a square hole, or the opposite, whichever is the hardest to fit in. I really didn't play a lot of kids' puzzle games with these kinds of things. And that's one of the things that they use. But here the federal government isn't having it, right? They're saying, no. Uber provides transportation. It helps facilitate the provision of transportation at least. And ideally, you would have changed this rule if you're the legislature, if you want this to apply to Uber and Lyft and those kinds of companies, to say essentially not provided, but provided or facilitated the provision of, right? And whenever you see contract language, when we read through an end user license agreement or something like that, and you see these long run on sentences where you say of specified public transportation services provided, or which facilitated the provision of, and you say, wow, we're really talking in old timey English. That's the reason, is you try to cover these holes when you're writing a contract or when you're writing a statute. And if this said facilitated the provision of, we wouldn't really have an argument here, because they are putting people together in order to have public transportation provided. Moving on from there, you can get in trouble if you have a failure to make reasonable modifications in policies, practices, or procedures when such modifications are necessary to afford such services or accommodations to individuals with disabilities. And you can see in other places very similar kind of concepts, including this one, which is what I said was really aimed at this particular issue, provided you find that Uber is a public transportation company. The entity shall ensure that adequate time is provided to allow individuals with disabilities to complete boarding or disembarking from the vehicle. Now, that is really aimed more at things like bus stops, right? The bus can't just press on and not let you into the car. Uber doesn't get paid if you don't let the person with the disability into the car. So this isn't really even a perfect fit there, but it's pretty darn close for a congressional statute applied. You could still argue that adequate time is provided. It's just charged a little bit more, but that in and of itself would present an issue. The point is not that there is a definitive answer on these things. The point is that statutes that are old don't do a great deal of stuff with company business models that are new. And so this lawsuit gets filed by the Department of Justice, and Uber basically says, no, we don't do these kinds of things. Or as The Verge describes, Uber instituted a wait time fee in a number of cities starting in April 2016, eventually expanding the policy nationwide. Passengers would incur the fee 2 minutes after the Uber car arrives at their pickup location and were charged until the car begins its trip. Passengers with disabilities, such as those who use a wheelchair or a walker, often need more time to get into the car than passengers without disabilities. Or, as this particular individual at the Justice Department says, people with disabilities deserve equal access to all areas of community life, including the private transportation services provided by companies like Uber. Clark said the goal of the lawsuit is to send a powerful message that Uber cannot penalize passengers with disabilities simply because they need more time to get into a car. Matt Coleman, a spokesperson for Uber, so this is Uber talking now, called the lawsuit surprising and confusing in light of Uber's desire to work with the Justice Department to address confusion around its wait times. We fundamentally disagree that our policies violate the ADA and will keep improving our products to support everyone's ability to easily move around their communities. Coleman said it was Uber's policy to refund wait time fees for disabled riders whenever they alerted the company that they were charged, which is a kind of opt into a refund approach, which I don't think is ever going to work when you find yourself in this kind of situation as a corporation. And Uber changed its policies recently, apparently very recently before the lawsuit, so that any rider who certifies they are disabled will have fees automatically waived, Coleman said. So we're going to call this the automatic waiver program. And this is going to be one of the ironies with this particular lawsuit. So what it looks like to me, reading between the lines, is that the DOJ starts talking with Uber earlier than their lawsuit, tries to get something done, either in a settlement, an acknowledgement, an apology, a payment provision, what have you. Uber doesn't really accede to that, but they do say, hey, we'll work with you. We're going to put together this automatic waiver program. You tell us you're disabled. Our app won't even charge the fees. They get that in place and it's working. And then the Department of Justice decides to sue them anyway. And that's where you get this kind of surprise notion. And ultimately, this waiver program will be, for the most part, the Department of Justice's solution here. And that can also make you cynical if you're inclined to do so. Ultimately, Uber isn't going to have to change at all because of this, even though the top line item winds up looking a little bit more like Uber will pay over $2 million to disabled riders after federal settlement from just a couple days ago. Regulators say the company's wait fee system discriminated against disabled users. And this is The Verge again, so you're going to get some of the similar kind of coverage. Uber has settled with the Department of Justice over allegations that it discriminated against disabled passengers. The DOJ announced in a press release on Monday. Oh yeah, we'll look at that. As part of the agreement, Uber will credit double the total wait fees issued to the 65,000 disabled riders already identified by Uber's programs and commit more than $2 million to funds for other affected individuals. So they're hiding the ball a little bit here. And you only get this when you dive in. This is one of the reasons I do headlines is like, I can't take anything on its face anymore. And it makes me sad more than anything. So one of the things that's happening here, and you kind of get it with the word credit. Uber will credit double the total wait time fees issued to the 65,000 disabled riders. This is Uber bucks right here. So the big chunk of people, this is Uber dollars. I think it's called Uber Cash, which of course kind of affects a company's bottom line, but also doesn't change their liquidity, doesn't actually expend funds on their behalf. And what you'll get in this particular instance is if you signed up, I believe, for the waiver program that was only in place for a short period of time before the lawsuit. And I think if you signed up during the pendency of the lawsuit, we'd really have to dive in there. And I don't know that the details are that important. You will get double the amount that you were charged for wait fees. And yeah, we'll just look into it. The $2 million basically goes to the complainers, whether you want to call them whistleblowers or what have you. This is going to be split between people that complain directly to the Department of Justice and people that complain to Uber. We're going to look at the settlement agreement so we can look at portions of that. But even here, I don't feel like what was communicated to the reader was that this big chunk, the most people affected, are going to get V-Bucks, right? They're going to get to spend more money on Uber. Class action lawsuits, everybody. And in this case, a Department of Justice lawsuit. The claims center on Uber's wait fee policy. We talked about that. While the fees themselves are typically under $1, plaintiffs argued they contributed to a broader system of discrimination. So that's one of the things I wanted to point out here from The Verge, is that we covered the part that talked about the story, and then they do something that a lot of outlets do. They drag in all the rest of this stuff about this company, right? Despite these changes, Uber has a fairly abysmal record when it comes to serving its passengers with disabilities. The company was sued by disability advocates in 2017. We don't get further reporting here. How did that go? Even the law probably moved on something that was filed in 2017. A report detailed excessively long wait times for wheelchair accessible vehicles in New York City. Uber sued New York City to block the implementation of a new rule requiring ride-hailing companies to make wheelchair accessible service a part of their operations. And the company in the city later agreed to a settlement exempting Uber and Lyft from that requirement, probably again because they aren't a perfect fit for who these particular bodies can regulate right now, given the current statutes that are at play at the federal or city level. But this is just kind of a tar and feathers approach to what is the overall story. You don't have to love Uber. Like I said, I don't have enough interactions with them to love or hate them. But you get this. A lawsuit filed in Pennsylvania in 2019 accused the company of failing to ensure that people in wheelchairs receive equal service from the company. They're just these throwaway sentences. And I'm not saying that they're necessarily wrong for context. But as a lawyer, I read these and say, okay, so they were sued in 2017. How did that go? They sued the city of New York. There was ultimately an agreement that they wouldn't have to do what New York wanted. So they kind of won that one. They're sued in 2019. How did that go? Being sued, at least to me as a lawyer, is not the end of a story about whether or not you deserve to be sued or what else was happening with you, right? It's not the end of what we're talking about in this particular instance. Federal lawsuit obviously raises the legal stakes for Uber. The Justice Department is not only seeking monetary damages for affected passengers, but also a court order forcing the company to comply with the ADA. Again, an order that says they will comply with the law is the same as the law. And then you have references to the lawsuit about a woman in a motorized wheelchair that just establishes kind of the fact pattern. And you get it again when we start talking about the settlement, right? While the fees themselves are typically under $1, as we talked about, plaintiffs argued they contributed to a broader system of discrimination. And as Britt Cormier says here, did Uber just offer store credit? Yes. The predominance of this settlement for 65,000 people is Uber credit. We apologize. Why don't you come back and use our services some more? And it's always going to feel a little bit bad, but this is the nature of these kinds of things. Reached for comment, Uber emphasized its commitment to equal accommodations for disabled users. We're pleased to have reached this agreement, said Uber representative Carissa Simmons. We are always working to improve accessibility for all users and encourage riders with a disability to utilize our self-declaration form to have wait time fees waived. Now, we'll see as part of the settlement that this is mandatory, that self-declaration is mostly accepted. We'll see what the Department of Justice let them do with that. The settlement indemnifies Uber from future disability claims concerning its wait fee system, but it's far from the only disability claim facing the company. Here's that litany of things that are problematic with Uber, right? Shortly before the Department of Justice lawsuit filed suit in 2021, Uber instituted a wait waiver program to reimburse disabled riders who have been hit with wait fees, but the change was too late to forestall the suit. Nevertheless, the settlement builds on Uber's existing waiver system, requiring Uber to continue the wait waiver program for as long as its wait fee policy remains in place. Kind of. Uber will also commit to keeping that information hidden from drivers to avoid discrimination in terms of which rides are accepted. As the settlement puts it, the company will not share information regarding whether a rider's account is exempt from wait fee times with drivers and will not make such information visible to drivers on the Uber driver app. Now, one interesting aspect of that is I would say, sure, the drivers don't get the wait time fees, right? They shouldn't have any interest in them whatsoever. But I would be interested to know from the Uber side or just from an investigative journalism kind of side, do they have any interest in that? Because if they don't, this is the easiest thing in the world to claim. If they would have an interest, right? These are drivers. These aren't employees of Ubers in most jurisdictions. And them waiting 15 minutes might be a problem. Like the big issue here with the waiver concept is that it's not narrowly tailored. You could have somebody with a disability whose movie also runs long, right? That, yes, it takes 5 minutes once they're in there in front of the car to get in the wheelchair. But if they show up 15 minutes late, if they're just fully waived from fees, essentially, do you have, instead of a second class of citizens, a super class of citizens with respect to this? That's why if I'm looking at this from Uber's perspective, I say, no, we should be able to charge fees if you're not at the car. And that will stop when you're at the car. And then we'll move on from there. And that will incentivize the drivers to get people, well positioned in the car if they need help and everything else. But it also avoids the problem of somebody with a disability is also a jerk, because people with disabilities have agency and they can be jerks. And so if I'm Uber, I would want to be more closely aligned with not just a blanket waiver, but instead actually tailoring what it is that we're talking about so that we capture the people who stay in the mall for an extra 10 minutes. Malls are still a thing, right? Yeah, I'm hip. And those who are at the car but just take longer to get in through no fault of their own. But that's how The Verge describes it. And this is how the Department of Justice describes it. Uber commits to changes and pays millions to resolve Justice Department lawsuit for overcharging people with disabilities. The Department of Justice filed in court today a multi-million-dollar settlement agreement with Uber Technologies, Inc. to resolve a lawsuit alleging that Uber violated the Americans with Disabilities Act. Under the agreement, Uber will offer several $1 million in compensation to more than 65,000 Uber users who were charged discriminatory fees due to disability. This number is the Uber bucks. In November 2021, the department filed a lawsuit alleging that Uber violated Title III of the ADA, which prohibits discrimination by private transportation companies like Uber. So this is one of the big fights. So the Department of Justice definitely thinks they have the right to regulate them. Uber doesn't. This settlement doesn't acknowledge one way or the other. According to the complaint, which is a really weird bit of language from the complainant, right? They wrote that document. This is a Department of Justice complaint. You don't have to cite to, according to the complaint, like it's an allegation. Forget it. It's like they're reporting on themselves from the moon. And it's just a bizarre way of treating this. The department's complaint alleged that Uber violated the ADA by failing to reasonably modify its wait time fee policy for passengers who, because of disability, needed more than 2 minutes to get into an Uber car. Under the 2-year agreement, so not forever for the waiver period, Uber has committed to waive wait time fees for all Uber riders who certify that they, or someone they frequently travel with, need more time to get in an Uber car because of a disability. Uber also will ensure that refunds are easily available for anyone who does not have a waiver and is charged a wait time fee because of disability. Additionally, Uber will credit the accounts of more than 65,000 eligible riders, there's a credit, who signed up for the waiver program for double the amount of wait time fees they were ever charged, which could amount to potentially hundreds of thousands or millions of dollars in compensation. Store credit. Uber will also pay $1.7 million or so to more than 1,000 riders who complained to Uber about being charged wait time fees because of disability, and $500,000 to other harmed individuals identified by the department. People with disabilities should not be made to feel like second-class citizens or punished because of their disability, which is exactly what Uber's wait time fee policy did, says the Department of Justice. This agreement sends a strong message that Uber and other ride-sharing companies will be held accountable if their services discriminate against people with disabilities. Your mileage may vary here. This is not a lot of money, and mostly the Department of Justice said, keep doing what you're doing. We'll talk about that. People with disabilities must have access to ride-sharing services provided by Uber and similar companies without enduring discriminatory wait time fees. And then we get to the settlement agreement. Yes, co-counsel. Is subscriber only on? No, subscriber only is not on. Sure. I've been ordered by co-counsel to put on subscriber only mode. So I will take a second and do that. I don't know why, folks. We're just going to have to work on this together. But we'll put that on, and then we will proceed with discussing the Department of Justice settlement agreement. While we do that, what do you all think? So far, we've looked at a bunch of different articles. We've looked at the way the Department of Justice is talking about this. And, well, it's not a lot of money. And as we'll see in the settlement agreement, mostly they're just going to be ordered to do what they're already doing. Now, that was late in the day. And so the Department of Justice is getting kind of a promise that they will continue doing that thing that they might have only done to essentially assuage the Department of Justice in the first instance. But is this a good thing? Is this a strong thing? Does Uber have a case? Does the Department of Justice have a case? So many interesting things to go into with one of these. And yes, I'm a lawyer. I'm naturally curious about these things. Hopefully, if you're spending time with me, you are too. Here's the settlement agreement. We did get that subscriber only mode on, honey. And we see the introduction. Here's the settlement agreement. It is expressly understood and agreed by the parties that this agreement represents a settlement and compromise of disputed claims, that factual and legal issues remain in dispute, and that the court has made no final determination in the action. So this is just a settlement. And as we've talked about in this space, that doesn't require anybody to admit that they did anything wrong in most cases. What the party that is accused of wrongdoing generally buys with a settlement is the fact that while we can all make our own intimations about what something like this means, they don't have to admit that they would have lost in a court of law. Title III of the Americans with Disabilities Act provides that no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of specified public transportation services. We read that. These private entities must ensure adequate time is provided to allow individuals with disabilities to board or disembark from the vehicle. These private entities that provide taxi services must not discriminate against individuals with disabilities for charging higher fare or fees for carrying them and their equipment. Again, if you're Uber, you can see where some of these ambiguities live, right? They're not charging higher fees for carrying people with disabilities or for carrying their wheelchairs. They're charging higher fees because their cars are being made to wait. And further, they aren't their cars, so calling them a taxi service is stretching what the law actually said. They have to modify in a reasonable way. In the action, the United States alleges that Uber is a private entity that is primarily engaged in the business of transporting people and whose operations affect commerce, putting them in that section, and that it provides specified public transportation services as that term is defined in the ADA and is so subject to Title III. The United States further alleges that Uber violated the ADA statutory and regulatory provisions by charging that wait time fee on rides where a rider with a disability needed more than 2 minutes to board an Uber vehicle because of disability. And that's an interesting way to describe what is a facially neutral wait time policy. The United States also alleges that Uber's actions amount to a pattern or practice of discrimination, and that the alleged discrimination against a person or group of persons raises an issue of general public importance. Uber denies all of this. Uber denies that it is subject to the provisions of the ADA, governing entities primarily engaged in the business of transporting people, denies that it is such an entity, denies that it provides specified public transportation, as that term is defined in the ADA, denies that it is an operator of a demand-responsive transportation service within the meaning of the ADA, and denies that it provides taxi services. Uber further denies that it is discriminated against individuals who have filed complaints with the U.S. Department of Justice or other individuals who allege that they were subject to discrimination, denies that it has violated any federal, state, or other laws, and denies that it has violated the letter or spirit of the ADA or its regulations in any way related to wait time fees or otherwise. Really? There's a denial of the spirit of the law? That's interesting. Uber asserts that drivers on the Uber platform are independent third parties and not Uber employees, and that drivers' vehicles are not Uber vehicles, which is the way Uber generally defends itself from these kinds of claims. By entering into this agreement, this is important, Uber does not admit and specifically denies any wrongdoing, liability, or fault. DOJ complainants. And we got some definitions here. This is just important to separate into the groups. The DOJ complainants are those individuals who communicated with the U.S. Department of Justice regarding Uber's wait time fees. These are the folks that contacted DOJ. Similarly, Uber complainants is defined as the 1,159 persons, less exciting in a press release than 65,000, excluding any persons also identified as DOJ complainants, we don't know where the overlap is, whom Uber has previously identified to the United States as having communicated with Uber about incurring a wait time fee. Now, just knowing how people operate, I'd be willing to bet that a good chunk of the people that complained to the DOJ were also people that complained to Uber. In fact, I would say it's almost all, that you would complain in both respects. By the time you're elevating things to the Federal Department of Justice, probably you've written a note to Uber, probably, which means that the 1,100 people is probably the top line item for folks that don't appear in this 65,000 count. Wait waiver accounts is defined to mean the accounts of approximately 65,000 users of Uber apps who, as of May 12th, 2022, so a couple of months ago, self-certified through the waiver program as having a disability and that this fee should be waived. That's the big chunk. That's what they put in their press releases. These are the people that are going to get Uber Cash, defined to mean a payment method within the Uber app that can be used to make purchases on the Uber and Uber Eats app, having a $1 Uber Cash to $1 US dollar equivalency value of US currency. Store credit, Uber money, Uber Cash bucks. First, we get the release, which we always do in a settlement. Except for the obligations and rights created by the agreement, the United States agrees to release and forever discharge Uber from any legal and equitable claims and demands under Title III of the ADA arising before the effective date. Just so we're clear, if you thought that paragraph was going in a different direction, they aren't completely off the hook for the ADA compliance. This is just a release for things that happened before this document would have been signed. And what will Uber do? What did Uber spend to get this release and settlement? Uber and its affiliates will continue to prohibit discrimination against riders. Okay. Uber shall maintain the waiver program that it made for as long as it charges riders a wait time fee at the start of a trip that may result in charges to persons with disabilities who need more time to board due to their disability. If Uber ceases to charge such a fee, Uber may at its sole discretion elect to modify or eliminate the waiver program. Except as provided in paragraph 26, Uber will not make any material modification to the waiver program without giving the United States 30 days notice and an opportunity to object to such modifications, and the parties will work in good faith to address any such objections, right? So all of this says that waiver program that you came up with before we filed this lawsuit, yeah, that seems good. For as long as the waiver program remains in effect, wait time fee waivers may be subject to verification and or audit by Uber, but Uber is not allowed to ask for medical info. Uber shall not require an account holder to disclose a specific medical diagnosis, provide medical documentation, or sign a medical release, but may require a description of the general nature of a rider's disability. And so they can reject these kinds of things, but it has to be based on objective evidence that a rider does not meet the eligibility requirements for self-certification. I suspect Uber would never do this. It's only bad PR. It only gets you back into the news. And Uber will provide mandatory training to current members of Uber's accessibility and disability team about how this waiver program works. So it's kind of a typical federal government settlement, except for the fact that Uber already has the solution in place, which is a little odd. So you're going to do the thing that you do, and you're going to make sure your people are trained on that thing that you already do. Uber will continue to make available a U.S. Help Center node through which riders can opt into the waiver program in substantially the same form as the node appears in the effective date. You'll keep doing what you're doing. And Uber will maintain its campaign to notify riders of the waiver program, consisting of 2 notices that are in plain language and web accessible inside the Uber Rider app. You will continue doing what you're doing. Upon request, and in any event, no more frequently than every 120 days after the effective date until 2 years after the effective date. So you're in a 2-year probationary period. Uber will look for stuff and provide audits to the United States. We'll look for complaints, complaints about not getting refunds, the number of requests for wait waivers that have been put forth. You will get an audit and information report whenever you ask for it in the United States, but you can't ask for it more than once every 4 months. Then you've got the funds. Uber will enter into a contract to retain Rust Consulting as the fund administrator. Uber promises that that's an independent third party. And then you get payments to DOJ complainants. Within 28 days of entering into a contract with the administrator, Uber shall deposit with the administrator a total of $500,000 to compensate DOJ complainants. $500,000 to whatever number of complainants that is. We didn't deign to tell you here in the settlement agreement because, well, it's not your money. The United States shall, in its sole discretion, decide what portion of the DOJ complainant payment account to distribute to each of the DOJ complainants. So it doesn't have to be pro rata. It doesn't have to be based on however you might have been injured. We just get to decide who we give this money to that otherwise complained to us. Similarly, we have a deposit of $1.7 million and change for those folks that complained to Uber. This will be a settlement fund, and Uber will send out some emails telling people that complained to Uber that they can go get their money. There's a whole lot of process here with days and notices and obligations there. And then the big number, Uber Cash to wait accounts. Within 30 days of the effective date, Uber will send an email to everybody and make available to them double the amount that they would otherwise be owed for credit in Uber Cash. And just as the kind of cherry on top, they'll pay $50,000 to the United States as a civil penalty. Cool? All right. We've got normal implementation and enforcement provisions here. We then have examples of the notices that they give out here. If this is to the DOJ people, we describe it, and then they say, hey, Uber will pay you X if you sign the attached release. And we don't know what that X will be because it's all set up by the United States government. Uber complainant email note. Hey, because you contacted Uber about being charged a wait time fee for needing more time to board a vehicle, you are eligible for a payment of at least $600. Not bad. From a $1.7 million fund under a recent agreement with the U.S. Department of Justice. How is that money going to be established? Who's going to be doing the establishing? Bunch of process things up above, but ultimately you sign this back in, you get an email about it in your inbox, and you decide whether or not you're going to file it with this particular settlement agent. Or because you opted into Uber's waiver program regarding wait time fees for riders with disabilities, you are eligible for a payment in Uber Cash under a recent agreement with the U.S. Department of Justice. Send in your information, and then we'll give you the double that you spent on wait times, even after signing up to the waiver program. And how much money is that? Don't know. But here we are. And that's what actually happened here. I think a cynically minded person could say Uber didn't really have anything happen to it. But it certainly got a lot of press in various places around the internet. So that's what I wanted to talk to you about. I think all this stuff is very interesting. I think it's a fun morning to talk about these kinds of things. What do you all think? Right? Let's talk a little bit about that. How does Hoeg read so fast and not make many mistakes? I make mistakes. I clear them up pretty fast, but that's just how I read. So I do like to get through things in a reasonable amount of time, and I really like to scare the people that are going to watch this on 2X and see if I can start to sound like the old Micro Machines guy when we're talking about these things. Many years of reading legal papers, that's also probably true. I have read a lot of legal documentation. Let's see here. When he's live, his logo does not show a red dot indicating he's live. Should show that I'm live. Who knows? Emily Aaron says, feels like a slap on the wrist. I think it does. When you go through everything, you think, okay, a couple $1 million, that already is not a ton of money, but that might be okay. But like the actual rules are, hey, you're going to keep your waiver program in place. You're going to give store credit to the vast bulk of people, and you're going to give some amount of money to the people that complained about you that is pretty de minimis. I mean, I don't know. Is that going to change Uber's behavior? I doubt it. But on the other hand, as we talked about at the top of the video, I'm not entirely sure the ADA is a great fit for what the Department of Justice just accused Uber of, which again has that kind of facially neutral policy, which yes, I think could be approved around the edges, where you effectively say, hey, if they're at the car, the timer stops. But otherwise, I don't know that Uber was necessarily violating those provisions that they were accused of violating by the DOJ. And if the DOJ knows that, if they know, hey, well, maybe we've got at least certain things here that are going to allow Uber defense, you start to see that settlement number come down, right? Because settlements are always an evaluation of what our chances of success are at trial, what that would cost us. And if the DOJ starts to say, well, they might have a point on X, Y, or Z, well, then you come up with a settlement that says, okay, keep doing what you're doing. 2 million sound good. 2 million goes out, give or take. We'll let you do all the rest of the people in store credit. And, that's the end of the day. Other people are maybe a little bit more cynical. Deborah, a reasonable interpretation is that Uber got another subsidy from the courts, that they were just allowed to do this. And effectively that the slap on the wrist was so light that this is evidencing a general United States Department of Justice push towards allowing Uber even more. Reba Darling, under store credit is a joke. Basically, their settlement generates more business for Uber, almost marketing, certainly with some of those people. The 1,100 people that are going to get some portion of DOJ or Uber's settlement money don't have to come back. That's real cash money. But I agree with you. The fact that they put in the headline 65,000 people. If you actually go back now that we've looked at the settlement agreement and get to this portion that says Uber will credit the accounts of more than 65,000, which could amount to potentially hundreds of thousands or millions of dollars in compensation. Yes, so long as they continue to use Uber, it doesn't look quite the same, right? From that particular perspective. Tracy Fagan, how does the law catch up with the kind of business Uber is? Got to change it. These aren't constitutional questions, right? We aren't as bound by those kinds of things. In general, the federal government is going to have the ability to regulate interstate commerce. Uber is almost certainly going to be that, only because it's using the internet. The states themselves, however, can get involved. And we've seen that a little bit with California's statute that's trying to make more independent contractors into employees. Now, of course, Uber and Lyft argued against that. And even though that law was targeted against them, they got exempted, I believe, from AB5. You can look at the AB5 video if you type that in. I think I used a dash, which may or not be appropriate for California. But if you search for AB5 on this channel, you will see me talking about it, particularly from kind of the perspective of game developers, because so many of them are contractors. But walking through that, I've also been on a number of podcasts talking about AB5 because I do think it's a potential problem, especially for folks that want to participate in a kind of gig economy and don't want to be bound by some of the things that employees wound up getting bound by because of the benefits packages and things that already attach to them. So you had a number of contractors that are ostensibly being protected in California that the state wants to protect argue against AB5 because it was essentially locking down their flexibility for what they could ask for and what they even wanted from these kinds of relationships. So yeah, let's see here. Shireen, woo, yes, may have to try everyone on 2X and see how it compares, but think Hoeg reads the fastest. I don't know. I think everybody reads pretty fast that's doing legal documents, because there's a lot of stuff that you can just kind of read at a cadence if you've gone through a lot of these documents. What else here? Midnight Yell, they got a judgment in California several years ago and nothing really has changed. That's where all of these policies come from. California is the most aggressive. Certain European jurisdictions, I think, are also aggressive against Uber, but Uber has a tendency to just threaten to leave various places, and a lot of folks really like ride-sharing services, so you've also got a political issue there, right? So what is the proper law? How should it be applied to these services? If we apply it differently, will they just leave? Is that actually something they will do if they're making a lot of money? Evaluating those kinds of things. Negotiations, folks, figuring out where the leverage is, how far you can push somebody, all of this stuff is very, very interesting, and comes out with a lot of these kinds of issues. My wife says she can only listen to me at 1.75 max, and that's in real life. She actually turns me to 1.75 all the time. Get to the point, but yeah, it's 2X I can't listen to myself on either. It took me a number of years just to listen to myself at all to do this editing, right? Let's see here. Secret McSquirrel says there's 560 people watching, only 200 likes. Yeah, sure, like, subscribe. Tell YouTube that we're here, especially if we don't have a red dot saying that we're live. We'll work on all of these things. You know, God knows the black box of the YouTube algorithm is unknowable to me, and I just try to get good content out there that I'm proud of. Having conversations with folks like you, frankly, you know, if it were only 2 people watching, I'd still probably do this. I enjoy these kinds of conversations and have fun doing them. But yeah, more people is better. YouTube likes it more. The channel likes it more. And that helps get people out here. Sardanism's Hoeg Law. Objection. Leonard French reads legal documents at the same place he explains them, but I admit he's the outlier. Same pace that he explains them. He doesn't switch speeds for the document. That's fair. I also like to, and some of this is kind of behind the scenes sausage making. I also like to use voices, which I know somebody complained about in comments. It's not to mock anything that I'm doing. I use voices, and I use the corporate voice if it's corporate messaging, because I want to separate out from when I'm saying something, Rick Hoeg, Virtual Legality, and when either the article is saying something or the source in the article is saying something. And I find it best if I do a little bit of that, and hopefully I don't do it too much, in order to delineate when I'm saying something so that that can help you tell when I'm editorializing, right? Oftentimes I'm explaining what we just read, but sometimes I'm giving an opinion, and I try to mark that both with language that I use and the fact that I use my own voice rather than doing something that I otherwise do for the document. So when I'm reading a source, sometimes I go faster because I want to indicate that that source is what I'm reading and it's not just me. So if I make it sound like that, that isn't just me pontificating or otherwise explaining. And if I do it that way, one of the things I found is that I can read at that pace, and I can evidence that it's a source. I can explain in the next sentence and go back to the source. And at least to my ear, it sounds clear that that's what happened, that it was source, Hoeg explanation, source. And hopefully that helps, because I also make podcasts out of these, right? I also put these in a podcast form where we're not just reading things visually on the YouTube. And so I do my best to still present things in a cool podcast form. Now, the channel lives on YouTube first and foremost. So sometimes I do refer to visuals and things. I try not to. Sorry, podcast listeners. But that's kind of the thesis there. Hopefully that's helpful. That's why I do it the way that I do it. Emily Aaron, sorry to go back to Amber Heard and Johnny Depp. It's all right. But her deadline for appeal is this coming Sunday. I suspect it's Monday, but it depends on the court because of the way you go forward from days that the court's not in session. So would she actually need to file by Friday, or do courts have weekend hours? Oh, hey, that was the question. So it'll be different by jurisdiction. So no, chances are there's 1,000 ways jurisdictions handle it. But the one I see most often is if the deadline comes up on a Saturday, it has to be filed by the Friday. And if it comes up on a Sunday, it has to be filed by the Monday. Now, courts with stuff that is this important, appeals filings, they might just always roll forward. I don't know what Virginia does. So maybe Rob or Kurt or someone that actually is barred in that jurisdiction might be better able to tell you. Rob in particular, since he works at the Fairfax court. But yes, generally speaking, if it's not court business hours, it'll roll one way or the other. Thank you for the question. Midnight Yell, Hoeg, I don't like Wednesdays because I don't have you to listen to while getting ready for work. I appreciate that. I really, really do. Having evaluated this thing, especially kind of in June and seeing how I feel, I need 1 day off, and I think 212 is the best way to handle that. Otherwise, we won't get any hangouts and headlines because I'll just break down somewhere and you'll just get a news report that'll be on somebody else's headline stream that says YouTube lawyer just collapsed in a ditch somewhere, and that'll be no fun for anybody. So I certainly appreciate that, but I think it's working. I think the 7:30 time is working. We might change times for the school year. I can give you that early warning. So we're in July. We're not near the school year just yet, but I want to help co-counsel. I want to see the kids a little bit more during that particular period of time. So we might move that time around for the fall and spring compared to the summer months. So we're going to see. It's constant experimentation here, and that's what we're doing. But I appreciate that. That is very nice of you to say. We've got people talking about AB5, Tanya Fox, AB5 totally screwed freelancers. AB5, I like I said, I was on a lot of podcasts. I took a lot of messages. I did the video about a lot of independent contractors that were very upset about AB5 killing their ability to be flexible and essentially not being allowed to work out of or into California for long periods of time. Now, that exception list has grown, as I understand it. And so a lot of them can continue to do some of the work that they were doing. But yeah, there was a lot of angst. There was a lot of animosity. And I don't think that that's gone away. One of the really interesting things in terms of American politics right now is will AB5 be adopted at a federal level, which would really change things in terms of the gig or freelancer economy in the United States. I don't think there's an appetite for that, but it would certainly be interesting. Co-counsel says he takes Wednesday off because I said you cannot stream 7 days a week. Oh, but I can. No, really, I would be in a ditch, honestly. Earlier or later for school year, haven't decided yet. Maybe I'll do a poll or something along those lines. My inclination is to bump it earlier and then potentially be available for car rides or something like that. But I really haven't gone down it very much. I haven't even gone down it with co-counsel yet. I just know I miss the little bits. I like seeing them in the morning. And so when it is the school year, we might do something differently. And I just wanted to kind of throw that out there. As co-counsel says, biggest problem is they changed the school time, and it would be exactly like the overlap between the drive time for co-counsel is like exactly what the show would be at this time. So like 7:30, 8:30. So we'll have to see. We will have to see, because I also like having co-counsel in the chat and being able to talk with my wife, maybe more than I do sometimes during my workday here live on the internet with you all. What else we have going on here? Good. I'm an educator. I'm entirely in favor of school. I'm sure that comes as no surprise to you. Oh my goodness, not earlier. 7 a.m. is already too early. Well, I'm doing 7:30 right now. One of the potential fixes is to move it to 7 a.m. We'd have to talk through times and things with co-counsel. That's a Hoeg House kind of situation. I just wanted to flag for you that I might be doing it at a different time. Snoopykin says, thank you for doing these at a time where I can catch them live in the Netherlands. It's a nice way to end my workday. Don't tell my boss I listen to this during work hours. I think there are worse things to be listening to. Hopefully, my voice helps you finish productively and that your boss actually sees an uptick in whatever it is that you do at your work. And then you can explain that everybody at work should be listening to Hoeg Law and Virtual Legality because it's good for the business. It's good for the employer. Who knows? Maybe we can work it out. Mrs. Hoeg gets to decide, in my opinion. Sure, absolutely. That is the way of those kinds of decisions, 100%. You are really sweet, Hoeg. Mrs. Log is very lucky, in my opinion. Let's go with your mileage may vary. I am very sweet many times in many days. I am also probably not the world's awesomest husband on other days, right? Marriage is a long road. I love my wife. Could not be happier with everything there. But I am positive there are days where if she wanted to, she could come into chat or just start up the camera and microphone and have some things to say about X or Y or whatever else I might have done. So that's the nature of human beings working, right? Libby S says, I listen to you every day while working. That's awesome. Absolutely. Love the voices. You were getting bots. Subscriber only helps take care of that. Yeah, I haven't been running subscriber only because I don't like the optics there. But we had been bot free for like a week or so. But I'll turn it back on for live streams, at least during that period of time. I don't love it. I don't like anybody to think that you have to have hit a button to subscribe to the channel to be a part of the conversation. But maybe I will pin something or put something in the description that says subscriber only mode is only ever on to try to kill bots. Like that's the only reason I ever put it on, not to drive subscriptions. But otherwise, yeah. Juju, no one is perfect. No one is perfect. We're all human beings, and that includes our home lives, our marriages, and our professional lives, right? I will freely admit that I am sure I've made mistakes in virtual legality episodes or talking about law or whatnot. All we can ever do is try to improve and try to be more accurate the next time and admit those faults when they come up. So that is how I live. That's how I hope to help people live. We're all fallible, 100%. The Heathers, Mrs. Hoeg can have her own microphone. Yeah, we'll connect her. We'll get her like a producer's button to say. But if we give her a producer's button, the squeaky door might not ever happen again. I don't know how you all feel about that. Apparently, my wife tells me that like the squeaky door has a fan club. So I don't know. Let's see here. Snoopykins, Hoeg Law, I work in government. What's this production thing you talk about? Fair enough. I'm going to leave that alone. I will say this. I work with a lot of regulators. I work with a lot of agencies. I talk to a lot of folks in various of these places. There are a lot of well-meaning people that want to help get things done. Like any institution, there's also a lot that don't. Either way, some of the hoops, some of the loops, some of the things that you actually have to do are so rote that it can sometimes feel like you're in Brazil, not the country, the movie, or Hitchhiker's Guide to the Galaxy or things like that. Big institutions, and this isn't limited to government, by the way. There are giant corporations that have this issue as well, have things so marked out in processes and procedures that I often feel badly for people that are trying to get things done and are otherwise hamstrung by that. So production, yes, giant institutions, giant groups have their issues. Individuals in those capacities I have often found to be helpful. I've also had bad interactions, but I've often found them to be helpful. That Sarah, earlier than 4 a.m. PT in the dark of winter, sad crying emoji. I don't know what we're going to do. We might just stick with this time. I have no clue, but I wanted to reflect on the fact that my time commitments and the family commitments are different now after the end of the Johnny Depp versus Amber Heard trial throughout this entire period into September. At that point in time, different things are happening around the house. Different things are occurring. And I want to be flexible with potentially moving this, shifting this to times that work. And I'll continue to ask everybody which times work for them. Let's see here. Squeaky Door Fan Club, LOL, which I almost read as League of Legends, which tells you a little bit of something about me. And I think that's about it. So it's about 8:46 a.m. Here again in the Eastern time zone of the United States. I think we went through a pretty depthful look at a court case, almost a virtual legality episode here. So I hope that was fun for everybody. Tomorrow is Casual Friday. Send in your DMs, any kind of casual stories that you want to cover. Casual meaning things that aren't as serious as the Americans with Disabilities Act and things like that. Co-counsel has something to add on this topic. She has flagged a question for me, which I will answer before I go. She only ever does this after I start my exit. Have you noticed this? I think that's because she knows I'm stopping. Okay, so Mrs. Hoeg Law has asked, don't miss this. Which of course I did. I'll get her on a separate Twitter or something. Dan Boy at Hoeg Law, have you played Sword of the Necromancer or Necrosmith? I have not. It's rare that I can say that, which with questions that I think are probably referring to video games. I have not played either of those, or if they're board games, I haven't played them either. So thank you for the question. I don't know. And then she says she doesn't know I'm leaving because she's on a 1-minute delay as the image of myself beams out somewhere and then back into the computer across the way. So yes, absolutely. Thank you for flagging me for questions. I really, really appreciate it. And yeah, everybody, tomorrow's Casual Friday. Send in any wacky articles. We might do the one about the Mogwais and Baby Yoda. We might do some other stuff that I otherwise have flagged. But if you have anything, best way to get them to me, DM on Twitter. DMs are open. If you think of anything that is kind of fun, goofy, weird, that's going to be the hope for Fridays, where after a long week of working and being productive and streaming and otherwise being good citizens on planet Earth, we like to chill out even just a little bit more. With that said, thank you to co-counsel. Thank you to everybody that has hung out with us today. And I will see you tomorrow for Casual Friday stream.